This production is brought to you by the University of Edinburgh.
Thanks very much, everyone. Suitably refreshed, we'll go straight into the second part of the seminar. Yep. And it's on the mythological legitimacy of constitutional adjudication. Professor Everson will be respondent again, and as the discussant, we'll have our own Ross Carrick.
Thank you. What I wanted to present in this part of this session is just to sort of go over what the key analytical points of view were in the book in relation to the mythological legitimacy of constitutional adjudication. So just to spell out the key claims, and then to just provide one or two critical observations about them. I think we'll find that a lot of the stuff that I say is actually works quite well with the stuff that we were talking about before. But what's different about here is that I'm focusing on particularly the constitutional adjudication setting, so looking at what actually takes place in constitutional courts and how constitutions form part of the sort of discussion on legitimacy. So first of all, what is meant by mythological legitimacy of constitutional adjudication? Well, as we were sort of alluding to in the previous session, broadly speaking, the phenomenon that we're sort of dealing with here is, as Professor Davis quite nicely put it, is how to make decisions seem right, or how to sort of just make it sort of seem like it's a good decision. What we're sort of talking about really is essentially social problems and how social problems can be solved, and not just how they can be solved, but how decisions that are taken in solution for the problems can be justified. And what we're looking at here is the difference between the way of solving those problems and justifying the solutions in the judicial setting versus, say, more deliberative political settings. So obviously in the judicial setting, it's the sort of the primary remit really is to justify it by reference to constitutional norms, whereas as opposed to justifying it on just general social norms or measures of social legitimacy. So that's the kind of the starting point almost. Is kind of we're looking at the phenomenon of solving and social problems and justifying justifiable solutions to them. So what I've thought I'd do is just as a sort of easy example to work with is to pick the social problem of the legalisation of abortion. If we imagine that, we know from popular media and TV programmes, etc., that it's a very hotly contested issue, particularly in the US. But it's a generally well understood political issue around the world. And I think that what's interesting about it is that it is a little bit trite to use it as an example, but it is also quite a genuinely complex debate. And there's a lot of kind of philosophizing about how you would go about reaching the right answer there. There's moral dilemmas, there's theological dilemmas, there's political problems. There's it attracts the interests of feminist groups and different sorts of groups. It has different manifestations in liberal ideology and takes shape in different social settings in different types of debates. It's a very complex issue with a lot of meaty discussion. There's no real easy answer to it. I'm bringing this in as an example to sort of say, first of all, if we imagine how those debates and the discussion over legalising a medical procedure called abortion take shape in the political arena, and I say political arena in a very broad sense, the way discussions take place and also the way decisions may take place in political arenas around that issue can quite easily and without much restriction delve into these sorts of deeper moral philosophical puzzles. They could quite legitimately bring in questions about what the Bible says about something that's related to abortion, or what sort of, different philosophical approaches to the question are freer to be able to be considered in political arenas. Whereas the sort of the main point here when we're looking at courts, and in particular constitutional courts, is that actually what represents the first order of the debate in a constitutional court is reference to constitutional norms. The question isn't so much on the sort of those moral philosophical deeper questions, that sort of displaced a sort of second order debate. The first concern, the primary remit of the Constitutional Court, is to consider how it can respond to the social problem as it appears in the legal setting by reference to a body of law. And obviously I'm alluding in this sense here to the famous and for some infamous case of Roe v. Wade, where this was precisely the issue at hand. In that case, it wasn't just simply that the court was simply deciding whether or not it should be legal or not. The court was specifically deciding whether or not the Texas law of abortion, or prescribing medical procedures allowing abortion, were constitutionally legitimate, or constitutionally valid in light of an entire body of constitutional law, both in terms of the written text, but also the implicit values that inhere within the written text. And that, I mean, even though, and for those of you that have read the decision, you will see that actually it's quite, I was surprised when I read it that the court did actually go into quite a philosophical discussion about it and raise a whole number of issues that do take place in political arenas. But the point here is that discussion and those types of discussions are displaced by, in terms of how they justify their eventual decision, by reference to what is actually permissible in terms of constitutional law. The decision was obviously that, according to the decision in the first instance is obviously that the Texas law of abortion had to be abolished because it was incompatible with the norms of the treaty. But the justification was precisely framed in terms of this imputed right of privacy in the 14th Amendment of the US Constitution. Now, the court obviously did consider a lot of the sort of philosophical problems associated with this social problem, but it's important to note that was put aside in favour of justifying the decision by reference to what the body of constitutional law said. So this way of addressing social problems and social issues in the Constitutional Court is not completely, but it's very much sort of getting towards what is the mythological nature of this legitimacy, and in particular that ultimately, as the sort of shining beacon of legitimacy, is this constitutional text. It's not so much really that, for example, that the rights, the autonomy of women prevail over, say, a notion of the right to life or any sort of theological assertions of what was right in this sense. It's actually by virtue of, or the legitimacy of the decision is framed by virtue of what appeared in constitutional text and how the meaning can be imputed there. So it's the sort of first order, second order thing. That's one part of certainly the way I understood that was my interpretation of the mythological legitimacy of constitutional adjudication. But this actually leads on to sort of what we were talking about in the last session, that part of the mythological legitimacy of relying on constitutional text stems from the fact that the constitutional text, as some form of settlement, however we describe it, has certain qualities which actually are in a sense mythological, or at least difficult to reconcile with a notion of legitimacy. And we actually touched on them in the last session. One of them is that it's a historically discrete moment. If we're thinking about it in terms of the U.S. Constitution, it's maybe a good example. It's something which doesn't necessarily apply to the here and now because of the sort of it has this historical reach. It was signed years and years ago, and yes, there's been amendments, but even still, even if the Constitution was drafted 2 years ago, it still got that 2 year. There's a sort of displacement in time there. So it's only sort of, perhaps for the briefest moment in history, it has this sense of legitimacy in reflecting the values of the people over which it has authority. The second mythological thing, or questionable legitimacy of a constitutional settlement, is, again, as we discussed, is the exclusivity of constitutional settlements. And we discussed this actually in the criminology seminar this morning as well, in terms of prisoners' voting rights, is that when we're talking about constitutional rights, they tend to just specify a particular class of people. And this takes on interesting sort of manifestations actually in EU law, and you mentioned this in the book as well, in the case of METOC, where we're talking about the rights of non-nationals or third country nationals for the rights and obligations in terms of EU law. Do third country nationals enjoy the same rights as nationals? And a more simplistic example would be, if should someone who's French enjoy the same social political rights and obligations as someone that's British in Britain? Should a French person be allowed to vote? I mean, that again essentially was what we ended up discussing in the criminology session. So constitutional settlements, by their nature, certainly in the historical record we have of them, they tend to exclude certain classes of people. And finally, is that they are, as Professor Everson put it in the book, they are potentially smothering of revolutionary politics. So because of their sort of stagnate nature, because they are sort of, especially when we think about it in terms of a codified document, they have these terms, these words which just stay in bits of paper and can't be changed. They sort of inhibit the capacity for revolution to take place because of the force of the meaning of those words. So that's the sort of start analytical sort of jump off point for them moving on, for the authors moving on to their argument for Verfassungsrecht, this alternative vision for how constitutional courts can sort of reject this orthodoxy of constitutional adjudication and actually adjudicate in a way which is more socially legitimate. So that's just to sort of spell out certainly my own interpretation of the mythological legitimacy of constitutional adjudication. And I just wanted to briefly indicate a couple of criticisms I had on these arguments. The first one, well, I suppose both of them are relatively similar, but essentially I think it's perhaps unfair that these criticisms or these arguments are focused on constitutional courts. I think the constitutional courts serve an important purpose. They serve an important instrumental purpose for the polity. In fact, it's obviously that there's various ways we can look at that. But just for two examples, I mean, obviously an important part of a political community is that, and if, again, I'm sort of assuming that we're sort of on the same page in terms of we're wanting a democratically constituted political community, that an important instrument for that political community to have its will implemented is courts and legal systems, to have law applied, and not just in the sort of the immediate obvious level of just he was speeding, so now he's paying a fine sort of thing, but also this is the very system, for the system itself to actually degenerate, to keep in place the very system of the rule of law. So in one sense it's applying rules of law, but also by courts following the text and by courts keeping with their law applying function. It's also ensuring that the rule of law is still observed within the broader community, and that this is very much, we couldn't really do without courts. We couldn't really do without courts doing that very thing, which, so even if the sort of criticism is correct that constitutional settlements have these mythological qualities, it doesn't necessarily tell us why we wouldn't want to have courts doing this particular function, because the people would still want to have these norms and still have these laws applied and still have the rule of law part of the system. I mean, I guess that's assuming an awful lot in terms of a conception of political theory. But, and the final criticism would just be, there is also, of course, as we discussed, the issue of legal indeterminacy, and that in particular the criticism targeted at the stifling of revolutionary politics. Well, to some extent, that's not necessarily the case, because courts and constitutional norms are very open-textured. I mean, obviously, the European Court of Justice is a very good example of this, because of the different I note that in your book you made reference to the way in which the Court of Justice eased in the European Parliament into the, giving it standing for raising actions, giving it extra sort of administrative bite, and that's against the sort of what not against what was in the text, but certainly it literally had to sort of say, yeah, this is the way we're viewing the way the text was written, and it doesn't say it here, but that's the way it is. There is always the potential via indeterminacy for revolutionary politics, but not in such a way that would undermine the validity of the whole legal system. I'm not suggesting that that's what you were arguing, but certainly these are just a couple of criticisms that I would point in your direction in relation to the sort of mythological legitimacy of constitutional adjudication. So I'll leave it to you.
Thanks very much. We've got another session after this one as well. It's really difficult. No, thanks very much, Ross. I must admit, veered away from things like abortion in the book.
Yeah, no.
Because that gets so very difficult. But to underline what we were trying to do there, it's a really interesting question about the people. Wouldn't they prefer a clear rule of law? And there's a certain reality there, as if obviously on the streets, law is the law, full stop. But our best kept secret, or amongst lawyers, is obviously the problem of indeterminacy. Is the problem of legal indeterminacy, and be it a constitutional court or be it a lower court, we are aware that norms don't have meaning. They simply have no determinate meaning. So at the moment of application, legal application of the norm, we have the, I can never say it properly, the interpositio auctoritatis, the authoritative legal assertion of meaning. So the interpositio auctoritatis, I've known from the Roman legal system this problem, and suddenly law in intervention gives authoritative legal meaning. So the issue becomes at that point, what, at least in a sociological constitutional conception, what legitimates that interpositio? Where is the justification? Law only becomes law at the moment of the assertion of legal meaning. There it only becomes law. They get the play on words, juridification and justification, that for it to be legitimately law, we must also justify the application. So the problem is one of how do we justify the application in one context. We know that the minute you start looking at the issue like that, the minute you wander away from a formal or a positive conception of law that can ignore indeterminacy, can just ignore it, you're in all sorts of trouble. And we have the very worst example in Carl Schmitt in the Interpositio Auctoritatis, who uses that as the moment for the assertion of us versus them. And that is perfectly legitimate in his conception of the political. So there is a huge danger, the Judge King. I'd say then that the job of legal theory, the job of critical law, is to find the form of justification. I can't say it, I can write it. The wordplay. It's not much of a wordplay if you can't say it. The juridification that also justifies. That's quite good, isn't it? The juridification that justifies its application and then legitimises it. So the whole of critical law, presumably, critical legal theory, is after that justification at the moment of legal application, which was also what I was after, and was after in a particular setting where constitutional theories, originalism, European law, there is no originalism, no textual immanence as well, maybe some textual immanence. Formal law, we've seen with the European Court of Justice that it simply could not have solved the problems it's been presented with if it had stuck with a formal application of the law. The problems were unforeseen. It's in the nature of the European Union. So trying to identify, is there a possible form of legitimation for that intervention at the moment of decision that we've seen so much in the European Court of Justice? I went also into this, obviously obviously I was hoping to find certain things because I did grow up reading Herman Heller and Harold Lasky and the sociological constitutionalism. I'll come on to that entire background. But we did go into it quite neutrally, and I didn't interview any of the judges we interviewed. Julia, my assistant, who was a BBC producer and is very good at getting people to say things, went away and interviewed them. And we drew up a template of a way to try and tease out of them, because obviously if you ask a judge, why did you decide this case? They're not going to tell you. We spent a long time with a template trying to find indications of what was in their head when they made the decision. And ultimately we came up with a complete mess. Between looking at cases and listening to what they're saying, they veer. They veer violently between a formalist perception an overtly political perception, I think, with the European Parliament. This is democracy, full stop. There's complete transcendental nonsense, that lovely old phrase from Felix Cohen? Felix Cohen, isn't it? The law of transcendental nonsense, where you just, you know. So what is the article? The article is well worth reading. Absolutely brilliant. Where you just assert something, and ultimately it means absolutely nothing. And you see the jurisprudence going back and forth. Underneath, trying to tease out, were you thinking about politics? Were you thinking about science? Were you thinking about some sort of objective way of looking at the world when you made these decisions? That occasionally came in. You know, there's a nice comment to the judge on electricity privatisation. Wouldn't it have been nice if someone had come to my court and told me what impact this would have on Europeans? I'd have liked that. But ultimately you've got a complete series of factors in their minds at the time. What can we conclude from this? Do we then just say that law is very much or the process of adjudication? If you say the essence of law is that moment of legal application where you justify the meaning you've given to an indeterminate norm, and you look at those processes and you come up with this wide variety of factors that work on the judge's mind when they decide, do we just say this is serendipity? Full stop. This is serendipity. Or do we try and find some framework, which is, again, what critical theory is about. Even formal law is about this. It's about trying to find a framework that will give structure to the decision-making of the judges and trying to identify those criteria that will help. As I say, formal law is part of it. Critical law and a sociological law, we have that added desire that the judges also respond to a changing society around them, and how to structure that. So this is the methodological weakness in the books. To what degree was I being objective, and to what degree was I trying to feed in my own thoughts? But no one has criticised that yet, but I'll raise it just to preempt. Ultimately, I felt it is necessary. We can't get away from the auctoritatis. We can't, the interpositio. It's simply there. It's always been there in every legal system. It's a problem we are all addressing all the time. We can't get away from it. We can't ignore it. We can mythologize around it. We can do something as dangerous as Schmidt did. We can create the us and them situation. But we can't get away from it. So trying to identify the structures there. That's it. Habermas again, Luhmann. Proceduralism has been the big response in the post-war. That you say, to avoid the judge that simply brings in their own personal views, we need to find a procedural way of solving this problem, a set of procedures that the judges can call upon. I don't think I move particularly far away from that, with the idea that politics is the ultimate arbiter, and all that the European judges can do is find a way to support a political debate. That is all they can do. Something around abortion, as you say, it's a political issue. It's a political issue. However, I'm not convinced, and I'm still confused by it, because there are other elements of substantive judgment undoubtedly involved in the mix, and I'm not quite sure how the courts can ever get away from them. We have, in the 1920s, the 1930s, the wonderful idea that to move the social law forward, to preserve the integrity of law, but yet respond to changing social circumstances outside law, you could use something like science, and by that is meant also social science, to act as law's mirror on the world. So you're not dealing in a preconception. It's a very naive view of science, that science, 20s, 30s, that science can give the judges the direct picture of what's going on. And that becomes part of critical law. It's also the background to law and economics, so it has its dangers as well. But we see the European judges doing that as well. We see them using science around proportionality. So there's still, it's not perfection. There's one element of substance there that they... And do I completely shy away from that? No, I don't, because it is very useful to use science in a forensic way to check that the political arguments that are coming to you are correct. So that's one element in the mix. Other elements in the mix, morality. Morality, shared moralities around the European Parliament. The judges, is that legitimate? Again, I ask myself, is it legitimate? Probably, because at that point of substantive decision, what else does the judge call on? What else does the judge call on? As long as it's an established morality. And then finally, the withdrawal from adjudication, a refusal to judge altogether, perhaps, when it all gets too much, a return to nonsensical formalism. Maybe that's actually acceptable at its moment of interpositio auctoritatis. Maybe that's acceptable. This is as far as I got in this book. Yeah? Looking at what's going on. So, headline, the only possible legitimacy at that moment of decision, legal decision, the only possible justification for juridification must be some procedural form of legitimacy that reflects a political process that decides. That's about the only form we can look at. But what does it consist of? What does it consist of? As I've said, I'm not wholly convinced by Habermas. I'm horrified by... Well, I'm not horrified by Luhmann. He's probably got everything right. But that degree of proceduralisation is just too much and is too painful to deal with. So pop it aside. Then just being very pragmatic, what did I find? I found the running back and forth between science, formalism, morality. I felt at the time that the European Court of Justice was justifying itself very well. It didn't go overboard in relation to science. It didn't go overboard in relation to morality. It only asserted morality in those cases where there really was common agreement around those points. It also, very cunningly, always withdrew from impossible decisions where too much was being asked of them by a retreat into formalism, textual immanence. Completely nonsensical, but not nonsensical to the degree that to have decided otherwise would have been to implicate that moment in a direct political decision-making. So that was the sort of scheme I found, and I was very positive about it in relation to the old European Court of Justice. What we'll probably discuss, is it perfection? Obviously it's not perfection, it's a muddling. sociological jurisprudence, it's muddling through. What we've found since, and I'm very clear about this, that the current European Court of Justice is hopeless. It is implicating itself in substance constantly. I do not think that the current court has the skills of the previous court. We might discuss that a wee bit more. But this was in as much as it's a theory of muddling. A theory of muddling. But also allowing for sociological development in the Heller mould of the law, also responding to society.
This production is copyright the University of Edinburgh.